Hey feds, I think this is something our employees need to hear. As you probably know, Treasury just told IRS and BFS employees that their union contract is terminated. But NTEU President Doreen Greenwald said, no, it's not. I agree with her. Here's the legal argument. Now, I'm not predicting what courts will do. I'm showing you the strongest legal argument for why a collective bargaining agreement doesn't just disappear because an agency sends a letter. IRS is risking a lot legally here. 5 points. First, statutes beat executive orders. Federal bargaining rights come from Congress. Title 5, Chapter 71. Congress said collective bargaining safeguards the public interest. If the executive branch wants out, it needs a lawful authority under that statute. I don't think a 2025 executive order is that type of authority. Second, the national security exclusion is narrow by design. Yes, the president has a tool to exclude an agency, but only if its primary function is intelligence, counterintelligence, or national security work. And Chapter 71 can't be applied consistently with that mission. That's 5 USC 7103B1. IRS collects taxes, BFS processes payments. There's a serious text-based argument that neither agency satisfies the primary function test. That isn't a frivolous argument, it's the statute. Third, a binding contract is not optional. NTEU is still the FLRA certified exclusive representative. An executed agreement is binding on the agency. Unilaterally declaring it terminated isn't contract administration, it's repudiation. Federal labor law exists precisely to prevent that. Fourth, the government already told the federal court this wouldn't happen. In NTEU versus Trump, the DC Circuit stayed an injunction in part because the government said agencies would hold off on terminating contracts while litigation proceeded. The court even said if a specific agency deviates, bargaining units can seek conjunctive relief. You don't get to tell a court harm is speculative because you won't terminate contracts and then terminate the contracts anyway. Fifth, OPM guidance isn't law. OPM can issue memos and templates. That's nice, but what it can't do is override Title V, and it cannot erase what courts already relied upon when weighing the equities. Bottom line, I think Greenwald's position is the rule of law position. Until these exclusions are finally upheld as applied to these specific bargaining units and the proper legal process can run their course, the contract is still the contract. So obviously I support unions, but I also want you to know if you're a federal employee, specifically an IRS or BFS employee facing performance issue or disciplinary action right now, I think the union grievance route may not be your only option. IRS might say it's not an option at all, even though it might be. And depending on your situation, it might not even be your best one. So if you're in one of those situations, a federal employee attorney might be able to help you figure out which path actually protects you the best. Follow me, this is moving fast. And again, this is general information, not legal advice. This is not even what I think the courts will do, though I could see the courts agreeing with me. I think this is the NTEU president standing up to something, in my opinion, that's unlawful. Thank you everybody for your support. Take care and have a good day.